Thank you. Good evening for attending GSRA's podcast, Talking to the Judiciary. I appreciate everybody attending. I'd like to thank, first of all, the Court Reporting Matters Committee for their careful consideration in this matter. And I would also like to thank the members of the court reporting community that have been involved with everything going on. Okay, so it hasn't started. Good evening, everybody. Thank you for tuning in. My name is Bill Abel. I'm the president of the Georgia Shorthand Court Reporters Association. I'd like to thank all the people who have helped put this podcast together. First of all, I'd like to start out by thanking the members of the Court Reporting Matters Committee for their hard work and putting out the recommendations and time for us to take a look at them. We do have some concerns about it. It looks like there's a lot of hard work that's gone into it, and a lot of the recommendations we're in total agreement with. However, we respectfully do disagree with a few of the recommendations. I'd like to go ahead and start by simply saying that we have some disagreements along the wording of electronic recording, especially 3.1c, and that we feel that it's just gone beyond the original scope that it was intended to do. Georgia Shorthand Report Association respects the fact that ER has a place in the courtroom. We're in total agreement with that. However, we don't believe that it has the place in the courtroom in the ANI proceeding. We believe it should be limited to courts of non-record, and it should be definitely kept out of the state and superior court. I'd like to direct your attention to 3.1c. We're simply asking for a one-sentence amendment in this regard. As it reads the way we want it to read, it would read, digital recording may not be used as the verbatim record in death penalty proceedings. Digital recording may be used, 1, upon the unavailability of a certified court reporter and as authorized by the court and operated according to this policy, or 2, as a secondary record of proceedings under a pilot project of limited duration to study the feasibility of a recording system. We believe that that's a wise, prudent choice. We're in favor of pilot projects. Again, we're definitely not in favor of using digital in a death penalty case. I don't think anybody is. And we are in agreement with it, except only in circumstances upon the unavailability of a live certified court reporter. Moving to 3.2, real-time reporting. It appears that it's been completely stricken out from the recommendations, because I'm reading it, it says the committee requests withdrawal of this policy pending further consideration. While we respect that, we disagree with that. We would like to see the wording inserted instead to say the Georgia Shorthand Reporters Association and Georgia Certified Court Reporters Association be tasked with submitting a real-time capability test to the Board of Court Reporting by June 2015. Real-time is the gold standard in the state. Any digital recording company will simply tell you that real-time court reporting is the gold standard within this state. We should strive for that. It's used in many, many courtrooms right now. It's a true cost-saving method. As court systems get used to it and they embrace it, I've yet to meet one judge who uses it that has not found a good use for it. And as it's an asset to be used in dirty and rough drafts, it speeds up the legal proceedings and gives access quicker and more efficiently. So we would again request that the wording be changed to the Georgia Shorthand Reporters Association and Georgia Certified Court Reporters Association be tasked with submitting a real-time capability test to the Board of Court Reporting by June 2015. Certain courts are already moving into that direction. Fulton County, for example, is going to be implementing a real-time requirement starting next year. That's a great first step. That is the gold standard. That should be expected in every state and superior court. Real-time capability. The recommendations originally were for real-time certification, which is an interesting wording, and I look forward to someone explaining to me how that came about. The bottom line of that would have been simply the elimination of the court reporting profession over a period of years. It takes many, many years. Some reporters have 25, 30 years experience and still are not certified. That doesn't mean they're not capable. We want capable, certified reporters in the courtroom providing a real-time feed. I think that's the gold standard. I think we should strive for that. Georgia should be the leader in that regard. There are many other issues that we have with the recommendations. The key word in the recommendations was that we misunderstood. I can promise you this. The Georgia Shorthand Reporters Association has no misunderstanding on these recommendations. I don't think anybody with intellectual honesty has any misunderstanding with regard to these recommendations. It is simply agenda-driven, in my humble opinion, to simply replace court reporters over a periodic basis with electronic recording. Say what they say, put it out however they want. That's just the bottom line truth of the matter. I've yet to meet anyone in private who disagrees. If that's the way they want to go, then they should put their cards out on the table, and let's have an honest debate about what is the best method of reporting in this state. I look forward to that. I feel that we will win that on every issue. We want the best in Georgia. We want the best court reporters in the courts in Georgia. We want Georgia to be the gold standard. That comes by embracing real time and demanding it for the whole public, for every courtroom of record. I would also like to bring up the fee schedule. The fee schedule is absent, completely dealing with civil takedowns, dealing with protection of civil litigants. The way it's proposed now, there is no mention of anything about any kind of civil protection for lawyers coming to the courtroom. I suppose the way this is written out during a civil day, that if there's 6 hearings, there'll be 6 different court reporters for 6 different lawyers for 6 different cases. Each of them will bear the cost of bringing in their court reporter. Each of them will bear the cost of the takedown and the eventual transcript versus one court reporter there at the time. Of course, if you're an advocate of ER, you say, well, we don't need a court reporter. If they want one, they can bring it themselves. It is an interesting philosophy because that will simply mean the poor don't get the quality of a real-time court reporter or a certified court reporter producing their record, because that is a cost that will be borne each and every time by each and every litigant instead of spread out over the day if there was a court reporter in that courtroom for the day. Also, a grave concern is the treatment of the recommendations dealing on the fee schedule with regard to state court reporters. Their takedown is being taken away. The per diem has been raised to a minimum increase. I asked myself when I first served on the Board of Court Reporting, how did we come about this per diem? How was this generated? I was told this the many, many years ago I served on the Board of Court Reporting, that the per diem was at the low rate. And let me repeat that. The per diem was at the low rate it was set because there were incentives based into their pay, such as takedown in state court for misdemeanors. So I was always under that assumption and could accept and understand why the fee of the per diem was at a certain rate, because there were incentives built into it. There are no more incentives, and there's a minimal increase, and actually a decrease in the workload. What's very interesting about that is that that will simply make it impossible for long-term reporters to remain in the state court. Unlike other people, I see no one willing to take a 30% cut in their pay and income. I wouldn't even argue this point or have a ground to stand on if the leadership within our state who advocates this type of stance were willing to take the same kind of pay cut. I would stand beside them, equal sacrifice. But I don't see that. I see people asking for increases, but we want to bear the burden of the decrease on the court reporter. The fact is that will discourage court reporters, high-quality skilled court reporters who are willing to put out the real-time feeds, true savings, best technology. They will not be interested in that kind of job. But there is one thing that will be interested, those that vote electronic recording. Call me paranoid, call me agenda-driven, looking over my shoulder, but call me on it. Challenge me on what I say. I look forward to that challenge. I feel I'll win it. This fee schedule is not acceptable for the state court reporters in the state of Georgia. GSRA put together a survey and sent it to the Court Reporting Matters Committee. Whether they got it or not, I don't know. But I do know this, that we will be sending out a booklet with that survey in it, along with all the letters, along with everything that we got, so that you can see not what is in the final package, but you can read the words. Again, They say that we're misunderstanding. I promise you, there is no misunderstanding on any of this. And if there is, challenge me in an open forum. Let's have a good debate on this. Let's promote the best technology for the buck. I would urge the Judicial Council to take a serious look at this fee schedule and ask how it came about. Ask if it's fair. Ask if that will promote and recruit the top reporters in the state of Georgia to come into the court system. The court system should have the A-level court reporters, not the second-tier best. But that's what you'll get if that's what you even want. These recommendations will simply, over time, discourage reporters from attempting to even become official reporters within the state court system. It just won't be feasible to make an honest living for the hard work they do every day. I would ask our state court judges to step up and vocalize what they see as concerns, because this will lead to eventual ER in the courtrooms. There's just no way around it. And again, I'm not hiding behind a committee. I'm speaking on a podcast. My words are etched in stone. I welcome any challenge to that effect. Let me say this. The judiciary is a great judiciary in this state. We want Georgia to be the best of the best when it comes to the legal system. Real-time court reporters provide the very best. Solid reporters who are real-time capable provide the very best. We don't want to take a step forward, backwards. We want to take steps forward. We look to be part of the solution, and we look forward to you guys asking us our opinion. Again, thank you very much for the hard work you've done. I've met a number of the judges on the Judicial Council, and every one of them I respect, smart, sharp, and have just done nothing but give me every opportunity to speak. But I don't feel we've reached everybody. As we get down to the final days, the decisions made are going to be crucial. The decisions made will determine whether we recruit the best court reporters in this state or we slowly phase them out. In my humble opinion, that's just really the choice we're at. Either the judiciary is going to embrace the slow extermination and replacement of court reporters, or they're going to step up to the plate and say, we want what every TV station gets. We want captioning type reporting in our courtrooms. We want the best court reporters. We want the record to be absolutely the best record it can be. We are the best. We look forward to the challenge of competitors and all the alternate methods. We beat them down, hands down, every time. But we don't have the voice that you have. We seek your guidance and your wisdom, and we look forward to seeing you on the 25th. There are many other issues we're going to cover, but we intend on sending you a booklet outlining all of our contentions in easy-to-follow formats. We just want to take a few minutes to say thank you for your hard work. We know you got more hard work ahead. We look forward to seeing you on the 25th, and after the 25th, we look forward to taking Georgia to be the best in the country. Thanks again. Have a good evening.